The Deputy Chief Justice Raymond Zondo is there at his chair. So let's listen.
Just started proceedings. Let's go live.
Good morning, Mr. Agrizzi. I'm well, thank you. Mr. Pretorius, you ready to proceed? Before
Yes.
we proceed, I need to deal with the issue that I promised to deal with this morning first. On Sunday, this past Sunday, a number of or certain newspapers carried articles concerning evidence that Mr. Agrizzi, who was already giving evidence before this commission, was yet to give. It would appear that certain newspapers had access to a copy of Mr. Agrizzi's affidavit that is before the commission. In some cases, it may be that they did not have access to the affidavit itself, but were given information relating to the contents of Mr. Agrizzi's affidavit by certain people. Obviously, there was no problem whatsoever with them publishing articles concerning evidence that Mr. Agrizzi had already given before this commission. But they went further, or some of them, and published evidence that he was yet to give in the commission. I want to start off by saying that I have the highest respect for many journalists and editors and newspapers who conduct their business professionally and in accordance with the law and with due regard to other people's rights. However, it seems to me that there are certain journalists, editors, and newspapers who decided that they would publish information relating to Mr. Agrizzi's affidavit, about which he was still to testify, and did so in breach of the regulation that I already told everybody about towards the end of last year. That is Regulation 11. Sub-Regulation 2 and Sub-Regulation 3 of the regulations applicable to this commission. Sub-Regulation 2 of Regulation 11 reads, "No person shall communicate to any other person any matter or information which may have come to his or her knowledge in connection with the inquiry, or allow or permit any other person to have access to any records of the Commission, except insofar as it is necessary in the performance of his or her duties in connection with the functions of the Commission, or by order of a competent court that relates to mainly the staff of the Commission, but it says no person. And then sub-regulation 3 says, no person shall, without the written permission of the chairperson, disseminate any document submitted to the Commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such documents, or peruse any document, including any statement which is destined to be submitted to the Commission, to the chairperson, or intercept such document while it is being taken or forwarded to the chairperson. Portions of what Mr. Agrizzi's statement says, which he had not dealt with, were the subject of articles that were published over the weekend, and that was done without any approach to me as chairperson to grant permission. I indicated last year that I would allow grant permission, and I was granting permission for publication after the witness has given evidence. I do not know whether the journalists and editors and newspapers who did so believe that it was in the public interest that they publish what Mr. Agrizzi was to testify about ahead of him giving evidence about it. I can see nothing that is in the public interest in the publication of what a witness is going to say a few days earlier when he is going to testify about it and it will be in the public domain. This is not a situation where a journalist thinks that information will not be made public, and therefore it is in the public interest that that information be published. This is a case where the journalist knows that this information is in an affidavit and the witness will testify about it, and the witness is not going to be testifying in camera. The witness is testifying in the open. So there is absolutely no public interest in supporting the decision to publish that information, because the information would, in a few days' time, be in the public domain after the witness has testified. So what is behind the publication of a witness evidence that is still to be testified about ahead of such testimony? It seems to me that it must be either because a newspaper wants to make money, or They just want to be the first one to tell the public what the witness will say. They see a scoop. But there is absolutely nothing in the public interest. The nation must know that newspapers and journalists who do that are not doing it in their interest. They are not serving public interest. They are serving their own interests. You know that this information will be made public in a legal forum, in a proper forum, in due course. There is nothing hidden, but you want to publish it ahead. You want to be the first one. You are not serving the public interests, whether you are an editor or you are a journalist. Unfortunately, I think that we have to look at this conduct in its proper context. The commission was established in order to look into allegations of state capture and corruption. We have had a lot of evidence about bribery and corruption since the commencement of the hearings of this commission last year. People who engage in bribery and corruption don't do so because they don't know what the law is. They know that what they are doing is against the law. But the law is, for them, an inconvenience for what they want to do. They want money, and they want a lot of it. And sometimes they want power, and they want a lot of it. And the law is standing in their way. It's an inconvenience. And because the law is an inconvenience, they will disregard it and do something wrong and commit criminal acts. Where does it start? It starts with what some might think are not big issues. I shared with the media and with the public last year what the law says in the regulations. No newspaper, no journalist, no editor has gone to court if he or she thinks that the law that says they may not publish the way it's indicated in the rules, in the regulations, if they think it's unconstitutional, they have not gone to court to have it declared unconstitutional, which would be the right thing if you think you have good grounds. It's not in accordance with the rule of law that any journalist or editor should decide, I don't care what the regulations say. I don't care what the law says. I want a scoop. I will publish anyway. It's wrong. It's unacceptable. It undermines the work of this commission. And for what? For a scoop. For making profits. As I've said, there are many journalists and editors for whom I have the highest respect. I thank them and commend them for the good work they do and for their professionalism. But it appears that there are some who find that they will not act in accordance with the law when the law stands in the way of what they want to do. I also want to say, when the media have issues on which they want the Commission to comment before they publish articles, they must give us enough time. It has happened at least 2 times, and one of the times was the past few days, when a journalist or media house plans to write a story and gives the Commission a few hours to comment or respond. And before the Commission can respond, they go ahead and publish. It happened last year as well. That's not the conduct of a journalist or newspaper or media house that is really interested in being fair to a body or person about whom they want to publish. It's somebody who doesn't care about the rights of the other person. Sometimes people who have had a long time to do investigations on an issue, and when they are supposed to write, they give the affected people a few hours to respond, as if you have nothing to do. You are just ready, sitting ready to attend to their queries. My understanding of the basic principles of journalism is that they include fairness to the people you are going to write about. And fairness must include that you give them a fair opportunity to respond to what you want to write about them. So I would appeal to the media, not just for the Commission only, but if you are going to write about people, give them a fair opportunity to respond to what you are going to write about them. We regard the work of this Commission as very important. We regard it as a national task. The Commission has men and women who are very committed to the work they do, some of whom, as you know, have been subjected to all kinds of insults in the media by certain people. They continue to wake up every morning and come to the Commission to do their work. I think it's important that they be given support. We would like to focus on the national task we have been given. We would not like to have side shows, to have to concern ourselves and spend time about what do we do about media that's acting in breach of the law. We would like to focus on the work at hand. This work is about our country. This work is about our nation. And I would think that each and every journalist would bear that in mind, and that you would like that we be given space to focus on this work. And one of the ways in which you do that is to please comply with the law. Please do not publish information in circumstances where you are undermining the work of this commission. Do not publish information in circumstances where you are acting in breach of the law. Support the work of this commission. Support the people who are devoting themselves to the work of this commission. Support the witnesses who come to this commission at great cost, some of them, to their safety and to the safety of their families, because they appreciate the work of this commission. There is no reason why you can't wait for a few days for the witness to deal with his or her evidence without it having been published ahead. And then after the witness has given evidence, you can write your articles, you can do your analysis. So I take this opportunity to appeal once again to the media not to act in a manner that undermines the work of this commission, but to support the commission. We obviously fully support the freedom of the media. There is no doubt about that. But we appeal that we all act in accordance with what is expected of us. The Commission will continue to give full cooperation to the media in regard to what they may ask us. We'll continue to deal with their queries as quickly as we can in the midst of everything that we are doing. And we just once again ask that the law be respected and that you support the work of this commission. I hope that everyone will allow us space to just focus on this national task. Thank you. The one other matter I want to mention is that while the evidence is going on this morning, a media statement will be issued, and I'm sure the journalists who are present in the hearing will be given copies relating to the appointment of the acting secretary of the commission. Thank you. Mr. Pretorius.
Thank you, Chair. Morning, Mr. Agrizzi.
Good morning, Advocate Pretorius. Are you well?
Yes, I am. Thank you.
That's good.
Mr. Agrizzi, we were dealing with the evidence in your affidavit at
Yes.
page 52.
That's correct.
We adjourned yesterday.
That's correct.
Can we start today at paragraph 27.1?
Yes, we can.
In that paragraph, you deal with the matters preceding and ultimately the conclusion of a contract with the Department of Correctional Services relating to high security fencing.
That is correct.
Would you begin with the events of 2005 and your discussions with Mr. Gavin Watson in this regard, please?
Thank you, Chair. It was June 2005. I had informal discussions, as we'd always have, Chair, with Gavin Watson regarding various things. And this specific morning, it was about high security fencing at the Department of Correctional Facilities. And I remember that the discussions were initiated by him. It was evident that he was aware that the department really needed some specific solution in this regard. And I was, at that stage, I didn't know that they needed something, but it was mentioned to me and he saw it as a potential business opportunity for the company.
Did you have the capacity within Bosasa to provide fencing, security fencing at that stage?
We'd never done fencing before, Chair. It was something new to us. We had never ever put up a fence.
Right. Did the discussion continue with more detail?
Yes, we actually discussed it. We said, listen, we don't have the capacity to do this. It was clear to me, sorry, does that answer your question?
Yes. Just go into more detail, please, in relation to the discussion. You deal with that in paragraph 27.2.
Okay. So it was clear that, you know, he had been thinking about it. And I know that him and at that stage, Danny Mansell was thinking about it. But anyway, he indicated to me that he had discussed the commercial viability with a gentleman by the name of Mr. Michael Rutenberg from Beta Bastion.
Just spell, is it Rutenberg? R-O-O-D-E-N-B-U-R-G?
Rutenberg, yes.
Yes. Sorry, I interrupted you. Please continue.
Not a problem. It was at that stage Beta Bastion, if I recall correctly, and then it then changed its name called Better Fence, during which the procurement of 26% shareholding of the South African branch of the company as a BE deal was raised.
Sorry, so before you go on, Beta Bastion, which later became Beta Fence, was that an international company?
Correct.
And who would buy 26% of the South African branch of that company?
That would be, well, that would be Gavin Watson.
All right. Was this proposal or contemplation processed?
Yes, it was.
Please tell the chair what happened.
Do you want me to talk about the BE deal? Sorry, Chair, just want clarity, or can I take you through what I say in my statement?
Well,
now the transaction was done.
He will clarify his question, Mr.
Yes,
Pistorius.
please just say what happened between Bosasa on the one hand and Beta Fence on the other.
Okay. Thank you, Chair, for the clarity. So Beta Fence, I was one day at the office and Beta sent some test panels. I don't know if the Chair knows what the fence looks like, but if you have a look at the Clearview fence, that's maybe the best example I can give. And I got quite a few panels delivered to Bosasa. They were delivered there, and I asked, you know, what are these for? And I was told, no, that we need to look at how we can utilize them, and are they up to the standard that I would put out in the facilities. At the same time, there was also a taut wire system that was delivered to the facility. And a taut wire system is basically a long box with wire, bobbed wire attached to it at intervals, strands, so that if somebody tries to touch it, it triggers an alarm which goes through to the control center. So I had no clue what to do with it. I really just, they stood in storage for a while. But then I later became aware of the fact that there was actually agreement that had been concluded already.
Sorry, tell the chair, please, what agreement was concluded?
So
between whom?
The agreement between Beta Fence and Gavin Watson, or Bosasa, I don't know, because it was actually Bopa and Pafoga, which are trusts, but I'll just use the word Bosasa. All right, so the agreement be included between them for the 26% deal. So soon thereafter, I attended a meeting with Watson was there, Mansell was there, Rodenberg was there, who's the managing director of Beta Fence. There was a gentleman, an engineer called J.P. Hobbs, and there's another gentleman called Rian, but I cannot remember his surname, but he was also from the same company as J.P. Hobbs. And during this meeting, it appeared that J.P. Hobbs and Rian were involved in a company called Techcon and Modutech. Those were the two companies. And what they manufactured Chair, was the taut wire systems, as well as a sensor which went on the wired mesh, which was a detection process system, a detection product for the system. What was interesting was I didn't really know about it, so I started reading up on it, and I understood that the specifications that they used it for was high security applications. So if you go to a facility that has the fence, you have the bowed mesh from Better Fence, then inside of that you have the taut wire system from Modutech. So those were the two companies. And then I started realizing that this has been put together for a reason. And this is why we're meeting.
Right. Just before you go on, at that stage, had the Department of Correctional Services published any intention or made known any intention to issue a tender?
No, there was absolutely no discussion of that. As a matter of fact, at that stage, they were actually under pressure financially because they'd used up their budgets, and I was battling to get payments out of them.
Who is they now?
The Department of Correctional Services.
Oh.
Why would then this series of events have occurred? In other words, can you explain why Mr. Gavin Watson would make all these preparations?
It becomes clearer later that it was a ploy between Mansell, Rodenburg, and Modutech, Rion, JP, bless him because he's not here, but the other people that were involved in it, that it was a ploy, it was a plan to capture what was left of the fencing business at Correctional Services. May I carry on?
Yes,
Chair?
please.
All right. I think the discussion really went specifically about how companies could work together, and especially on getting a project with Correctional Services. And one of them raised it that, well, perhaps what should happen is that Sondolo should subcontract to one of the other bigger companies. And later, the two companies, I mean, between Modutech and Sondolo, they then became the primary suppliers. So Modutech did the taut wire, and Sondolo did the installation of the cameras, the metal detectors, X-ray screeners, if there was necessary. They did the installation of alarm systems, all that type of thing. So between the two companies, they were the suppliers, but the third company was Better Fence, who would supply the welded mesh.
All right. Well, whether by way of subcontract or whether by way of cooperation, or whether by way simply of becoming a supplier to the main contractor, there was an arrangement, or a contemplated arrangement at least, that there would be cooperation between various entities with the prospect of supplying fencing, security fencing, to the Department of Correctional Services.
That's correct. Right. The additional thing is the beauty...
Just before you go on, Sondolo, at that stage was Sondolo IT Pty Limited, a Bosasa Group company.
That's correct.
Right. Okay, go on please at paragraph 27.6.
Correct. At that stage, there was a lot of controversy already about the Bosasa Group. So I was not directly involved, but I'm giving you exactly as I know it. So Gavin and Tony Perry and Danny Mansell negotiated with Michael Rodenburg and a lady called Jean Rodenburg, Michael Rodenburg's wife, and a lady by the name of Gloria Josephs, all right, to buy a company which was owned by the Rodenburgs and Gloria Joseph, called Pezulu Fencing. I don't know the specifics of the actual agreement, but what I do know is that the sale was destined only to go through once the contract had been awarded to Pezulu. That was made very clear to everybody. It's public knowledge at Bosasa that we had to avert any negativity at that stage towards Bosasa, and the only way you would avert this, because this is a massive contract, one of the biggest fencing contracts ever done, you know, and because they didn't want attention, we said they said, all right, Pezulu's there, award the contract to Pezulu. And on top of that, the sale would only go through of Pezulu once the contract had been awarded to Pezulu.
So that's the sale in broad terms of the interest in Pezulu Fencing Pty Limited to Mr. Watson or to
Ballpumper 4. Let's rather use, let's not personalise it, I think, Chair. Let's use Ballpumper 4.
Those are two trusts in the group of entities under the BASASA
Yes.
Control or management.
Correct. And the sale would also only go through when the Duplo fencing, because we call it Duplo.
Yes.
And it was called the Duplo fence. So that was the fact. It was done to hide that the BASASA group would receive any more contracts.
Okay. Carry on, please.
Yep. During that period, it was also agreed that Gloria Josephs, who was heading the company and was a shareholder, together with Michael Rodenberg's wife, in Pezulu, would be paid a nominal fee of a few million rands for the company, but then they would be allowed to subcontractors Gordian, PDY, Ltd. Gloria would have only really to appear in meetings as the quasi-CEO, as Pezulu CEO, and should basically just be there for name only. But the management of Pezulu was taken over from day one of the signing of the contract. But the shareholding would only come through later.
All right. That may be a bit confusing. Did you want to say something, Chair?
Well, if you say it may be confusing, I'm sure you're going to ask what I wanted to ask. Go ahead.
Let's take it step by step then.
Okay.
In order to carry out the arrangement that was now contemplated between these various role players, it was contemplated that a company would be bought called Pezulu Fencing Pty Limited.
That is correct.
As I understand what you're saying, it was contemplated to or decided that the shareholding in the company would only be transferred to the buyer, the BASASA trusts, once a contract had been awarded by the Department of Correctional Services.
That's correct. And it would be a process, to add explanation, it would be a process that would be undertaken undercover, very quietly, so that nobody really knew about it and nobody would question it.
But the management of Pezulu Fencing, I understand, was immediately taken over by interests within the BASASA group.
That is correct, Chair.
One of the shareholders at the time, that is before the shareholding is transferred in terms of the agreement, was a Ms. Josephs.
That is correct.
And you say she was Mr. Rodenberg's wife.
Incorrect. Chair, Mr. Rodenberg's wife was Sean Rodenberg, and she was a shareholder, as was Gloria Josephs.
Oh, I see. Ms. Josephs and Mr. Rodenberg's wife were both shareholders in Pezulu Fencing.
That is correct.
Before the shares were transferred.
That is correct.
Were they the only shareholders?
Chair, no.
Or there were other shareholders?
There were other shareholders. I cannot recall who they are.
Okay, but was your understanding that together they formed, they held the majority of shares or not?
Together, Sean Rodenberg and Gloria Josephs hold the majority shares.
Okay, thank you.
And although their shareholding would in due course be transferred to interests within the BASASA group, they would retain an interest in the arrangement, I understand, through another company, Gordian Pty Limited, and that company would subcontract within the contractual arrangements.
Yes, so the agreement was, just to recap, Chair, for clarity, BASASA would pay a couple of million rand for the shareholding in Pezulu, as well as agree to subcontract a large portion of the tender to Gordian. That was the arrangement that was made.
Yes, thank you.
Right. Were there other contractual arrangements made at the time before there was any talk of the Department of Correctional Services issuing a tender?
Correct.
What were those arrangements? You deal with them in paragraph 27.8.
Yes. At the same time, we entered into a supply agreement with B-Defence, whereby where at the time when Pezulu Fencing is awarded the contract for the Department of Correctional Services for the Duplo or the double fencing, B-Defence would supply all the fencing material to Pezulu Fence, and it would be at a lower cost, so it would be at base cost. Now, the Duplo fence, if I can give a little bit of history to it, is a normal mesh fence, and we put an extra strand on the outside of the fence, which gives it slightly more rigidity, but what it does do is it changes the makeup of the actual product, which is then patented. So, in actual fact, it was my idea, Chair, but Mr. Michael Rodenberg patented it under his idea. Didn't worry me. But just so you know the detail, nobody else could manufacture that fence because it was patented. So there was a premium price put onto it, Chair. So anybody could buy it, but they would have to pay the premium price. Whereas the tendering, the cabal that put this together basically had a price advantage of 30% already. So
that is because the agreement between B-Defence and Bosasa, and I use the latter term loosely, was that B-Defence would supply fencing material to Pezulu Fencing at a lower cost than it would supply those materials to any other company.
Correct.
To any other competitor.
That is correct.
And was there any quid pro quo or any benefit to B-Defence?
Well,
or to
B-Defence
Bosasa?
At that stage was financially in trouble in South Africa. They were literally in a bad state. So they needed a massive transaction like this. And at the same time, they also needed empowerment. So they had another company called Syngenta. And unfortunately, as I mentioned yesterday, I did not have time to put everything in. But this company gave up their 26% shareholding, which was then given to Bopa and Paforba, so that they'd have empowerment as well. Not a cent was paid for the shareholding.
So, as part of these complex arrangements, B-Defence and another entity you mentioned, spell it please.
Syngenta, it was a group called Syngenta, S-A-G-E-N-T-A.
Right, those two entities transferred 26% of shares in which entity?
In B-Defence.
Yes.
In B-Defence, and it was transferred over to the two trusts that are held by Bosasa.
Yes, and those two trusts, as you've told the Chair, are BOPA, B-O-P-A, and Pafoga, P-H-A-F-O-G-A.
That's correct.
Right, now, before we go on, you've told the Chair of a very complex series of agreements, understandings, and intercompany share transfers.
Yes.
And you say this was done in contemplation of a tender to be awarded by, or tender to be awarded, yes, by Correctional Services.
That's correct.
But at this stage, there was no public announcement of any such tender being issued.
Nobody even knew. I don't think Corrections knew themselves.
Right. Continue, please.
Also,
in 2005.
I'm sorry. Why do you say you don't even think Correctional Services knew themselves?
because it was a shock to them when the tender started coming out. I remember attending meetings.
But then who issued the tender then?
Well, it was corrections, but maybe I should clarify, there was maybe 1 or 2 individuals or 3 individuals that actually knew about it. It was done totally, because remember, normally this chair would go through Public Works. Public Works is responsible.
So, is that what would normally happen?
Yes, yeah.
Okay.
Normally
Fencing for government departments.
Correct. So if there was a need, they would have to put a need in. Public
Yes.
Works would attend to it. But I don't want to digress into that. I can't talk about that too much.
Yeah. Okay.
But what I can tell you is that in 2005, Chair, I went to Bloemfontein with Danny Mansell. We flew in. I remember it because we nearly crashed the plane because they overloaded it. So it's vivid in my memory. And we met with the Grelings at SA Fencing Gate. And the goal of this meeting, which I only found out when I walked into the offices of SA Fencing Gate from Danny Mansell, was that they needed to become subcontractors to Pezulu Fencing after it had been awarded the Duplo Fencing Correctional Services contract for the installation of the fences. And that wasn't the only one. That was the only one I attended. But other arrangements were made with a company called Livewire, Gordian, Mavundla Ironclad, and L&J Civils. L&J Civils was a company that was owned by Mr. Danny Mansell and Jared Mansell, his son. And his other son was Willem Mansell, but I cannot recall if he was a shareholder. And there was a gentleman by the name of Jacob Hitze who represented a company which I just cannot remember. This was over 14 years ago. So the arrangement was what they agreed, which I was told, and I was there. The aforementioned arrangement required each of them to submit separate tender applications for the Duplo fencing tender. So what I'm trying to explain, Chair, is that the agreement was we're submitting as subcontractors for Pezulu, but at the same time, we're also submitting as our own company. So,
is that normal?
Well, no, it's not very normal. It's not normal at all.
Well, when you say submitting as subcontractors, let's bear in mind that no tender or invitation to bid had been issued at this stage.
Nothing whatsoever.
Let me ask you, why would all these complex and detailed arrangements be entered into if there was no tender on the horizon?
The reason, Chair, is because let's get our ducks in a row. This is the biggest fencing tender in the history of South Africa, Africa, and probably the Southern Hemisphere.
The fencing was, what was contemplated was that the fencing would be done for correctional services throughout the whole country.
Correct.
Okay, all right, yes.
Originally, the plan was to start with phase 1, phase 2, phase 3. Phase 1 would be the fence at 47 of the centers of excellence, they called them, to make sure that everybody sees them, and at that stage as well, there was quite a few escapes and that type of thing. So this fence would prove as the solution, the utopia of how to run a prison. And it's being applied it's a very good system being applied internationally. And South Africa's prisons would be the first in the world to have all of them using this technology. But it was also the monopolizing of the fencing contracts with correctional services, because once you were in for life. You controlled the source, you controlled the client, and you could rape our country of as much as you wanted to, because you just start charging more and more and more. That's a fact.
Let's just clarify one answer you've just given, Mr. Agrizzi. You spoke of the group of companies and entities who would act as subcontractors to Pezulu Fencing.
That's correct.
If there was to be any response to any bid to be issued in the future, those subcontractors would be part of a bid on the part of Pizulu Fencing.
That is correct.
But you say there was also arrangement that these various entities would bid separately for any tender that was to be issued by the Department of Correctional Services.
That is correct, but perhaps I failed to explain that. They would bid in a controlled manner.
Yes, we'll come to that in a moment.
Okay.
Did you say those companies that you are talking about would be the ones listed in 27.9?
Correct.
Livewire Pty Limited, Gordian Pty Limited, Mavundla Ironclad Pty Limited, LJ Civils Pty Limited, and you say there was another company which was represented by somebody called Jaco Pilzer. You can't remember the name of the company.
That is correct.
Okay, thank you.
What you don't say in your statement, and perhaps you can assist the chair in this regard, Mr. Agrizzi, did anyone in Bosasa have any knowledge of what the intentions of correctional services were in relation to issuing tenders for the provision of high security fencing?
Are you, sorry, Chair, I want some clarity. Are you asking me, did somebody in correctional services liaise with somebody in Bosasa and knew what they wanted out of this deal?
There is the question, but let me just give you some background to the question so
Yes.
you can understand why I'm asking it.
Yes, Chair.
There are two possible scenarios. The Bosasa decision makers could have been very confident that they would persuade correctional services to issue a tender, and therefore it would be worthwhile to go to these great lengths to prepare for the provision of such services. Alternatively, the decision makers in Bosasa could have known that such a tender was about to be issued. Do you know which? And the former situation would arise where there was a degree of influence exercised by Bosasa over Department of Correctional Services officials. But you tell the chair if you know anything about
Chair, this
what was happening between Bosasa and Correctional Services before the tender was issued.
Chair, this, and I'm being very frank, because what you said this morning was so true. I didn't come here to be crucified by the press. I came here to rid this country and to try and help free us of all the corruption that is killing us and is destroying our future of our kids. So the answer is very simply, this was caucused. Correctional Services, specifically Richmond, Lyndham T, and Patrick Gillingham would do as they were instructed, as they had been captured by Gavin Watson, Danny Mansell, and Bosasa, including myself. Sorry,
So,
does that answer the question?
I'm sure it does, and Mr. Pretorius will ask further questions if he wants you to give more. So basically what you are saying is there was a discussion involving Bosasa and Correctional Services in the form of Mr. Lyndham T and Mr. Gillingham that had preceded these arrangements being made.
Correct. And the rest of my affidavit will actually show on this specific topic how it went about.
Yes. Thank you.
Thank you, Chair.
In regard to the tender about to be issued, was anything done by anyone in Bosasa regarding specifications?
Mr. Mansell compiled the specification documents for 47 of the Department of Correctional Services facilities, Chair. This was for the fencing and the security. He also did the specification for the taut wire So what he did was he got the companies to do the tort wire to actually just provide specification and print them and put them into the specification. He personally sat and did them. I know that. I attended one or two of the meetings. At that stage, he was staying at the Cedar Lodge in Krugersdorp. You know, he had quite a large room, and he had often asked me to come over there and just have a chat with him in the evenings. And I would go there and we would just talk generally. But I think he was lonely and he needed to talk. Much like I do right now.
Did you have an opportunity to look at that specifications document?
Yes, I did.
And again, just to confirm, did this occur before any tender was issued?
This happened before any tender was issued. And then I can add to this if you need be, Chair.
Yeah, do so if it's relevant to what we are talking about.
It is. It's
Yes.
part of my statement.
Yes.
So he also informed me at one of these meetings that his son was already working on the various correctional sites already. Now this is before tenders even promulgated. And he was doing surveys with a specific theodolite that we had bought and an engineer that we had employed, unbeknown to myself, and he was plotting out the various correctional centers already. It was disturbing because, gee, how can you go and work on the site and rather let them do it, let them do the spec. And this happened long before the tender documents were even issued. So those theodolite plans and that were ready before the tender specification was always ever put out.
So not only, let's just summarize, not only did BSASA personnel compile specifications, but also had access to correctional services sites in order to survey those sites, in order to assist in the preparation of the specifications and any bid documents that would be submitted in the future.
That is correct, Chair. If I can give you an example.
Yeah.
It takes you, on average, 2 days to do, say, Johannesburg management area. You had 47 sites to do. Take 47 times about 2. That tells you how long before the time, more or less, it was done.
Well, you say, well, did other potential
I'm sorry,
bidders
Mr. I think he hasn't finished.
I'm just giving you how long before it was.
Yes.
So if you take 47 sites, it'll take you at least, let's say, just a day to do a site. Let's say we're working really hard. 47 sites times a day gives you 47 days.
But you are saying what's more likely is much more than that.
Correct.
Yeah. And if it took 2 days to do each one of them, you are looking at probably more than 100 days ahead, and probably much more than that.
You're 100% correct.
Yes.
Would you explain to the Chair what advantage that gave the BSASA enterprise in relation to this bid, in relation to the position other potential bidders would be in once tenders were issued?
Treasury regulations are very clear that the bid must be advertised and there's a period of time that it must lay and the response must be in by a period of time. So I cannot recall exactly when the response was off the top of my head. We can get to that later in my statement. But the benefit is that if I had done the surveys with a theodolite at all the facilities that would come out on tender, by the time the tender is put out, I've done all the work. The other people have to run around like mad to try and measure the sites and get the distances and all that accurately. The advantage is, that the BSASA group through Pezulu and Bopa and Pafoga had the advantage. We had a headway before everybody else could even see the spec.
Just to confirm what I think you said already. So the idea, as you came to understand it, was that for this particular tender that was going to be advertised in due course, Bosasa did not want to be the ones who would submit a bid. Phezulu would submit the bid, and then Bosasa would benefit in effect and in reality through the arrangements that it would have made with Phezulu and with everybody else that you have told us about.
That is correct, Chair.
Thank you. And that was because the negative publicity about Bosasa had already started, is that right?
That is correct, Chair.
Thank you.
So the idea, as I understand it, was that Phezulu Fencing would be awarded the bid, and as soon as that occurred, the shares would be transferred to Bosasa.
Well, to the two entities, Bafoga and Bopa, yes.
Within
but
Bosasa.
Indirectly Bosasa. It's all these various names in that, Chair.
So technically, the shares would be transferred to the trusts. I think you said two trusts?
That's right.
Two trusts which fall under Bosasa or the Watson family. Is that right? Or Mr. Garvin Watson?
You're 100% correct.
Technically, that's what they would be. The shares would be transferred to those trusts, and then what those trusts did with them, then it was up to them. And but that was those trusts were part, basically, for all intents and purposes, of Bosasa.
You said it, Chair.
Thank you.
In paragraph 27.12, you deal with your particular tasks in the bidding process. You talk about the bidding process. Of course, we know from your evidence that there's no bidding process at this stage. But what tasks were you asked to perform?
Okay. I was asked, Chair, to oversee the bidding process. Normally in the group of companies, I would be personally involved with every single bid that went out of the company through the bid office. So I was asked to put a team together to draft the tender bid and the submission thereof. I requested that I was...
For Phezulu now?
On behalf of Phezulu.
Yeah, on behalf of Phezulu.
That's correct.
Okay.
So I requested that, another team be put on the project because there were people available that weren't busy. But I was extremely busy. It was at a time when we were extremely busy operationally. I was spending weeks away on the various catering sites and on the Sondolo security installation sites. So for me to get into the office, to do the research, to write up on fencing, and especially because I knew nothing about fencing, I didn't enjoy it. I didn't want to get involved with it. So they agreed. It was agreed, but it was told to me that from the management and directorate that I must still keep oversight. They would release me from it, but I need to be there for oversight and to make sure that the quality of the product put down at the end of the day was suitable. So from my side, I just maintained oversight. And then what happened was I then learned later on that the team that had been put together, which comprised of certain people that had been recently employed from a fleet management company that worked with Transnet, I think it was called HSA. So there was a team that we employed from them, put them in there. They then did the tender and the bid submission. And it was done in conjunction with various of the representatives from the various other fencing companies. Because remember, by now, the agreements had been tied up with the various companies to do that.
So the preparations for the response to the invitation to bid were made in collaboration with various other entities that were to bid separately.
That is correct.
Right, and did you see anything in this regard yourself? You deal with that in paragraph 27.13.
Interesting. I attended the office, and if you know, if you've been to my office, you know that my office was on the right-hand side in the executive block, but the executive block doesn't have nice toilet facilities, and I always like to go through to the main boardroom where I would utilize the facilities there and make myself a coffee and then go back to work. So one evening I was there working late, and I walked through to the boardroom and I saw every single one of the companies is listed there. They were all working on the bid. So in one of the boardrooms, everybody was seated around the boardroom, and they're busy working on the bid document and the submission of the bid itself. I then raised a concern. Two reasons. Number one is I asked, did you switch off the camera systems? I remember this vividly, and it's not in my statement. But I asked, did you switch off the camera systems? Because if that's happening in the boardroom, there was at that stage a camera in the boardroom. I said, it's not a good thing to show everybody sitting around the same table doing figures. And I raised this concern with both Danny Mansell and Mr. Watson. Like everything else, I was always told, don't worry, we have it all under control. Does that answer?
Were the two also there, or they were not at in that boardroom on that occasion?
They were not in the boardroom. They were not in the boardroom at that stage. They were outside the boardroom. And then they actually came and sat in my office, and they were in and out of my offices as well.
Did you say this was in the evening?
Yes, it was one evening, 7 o'clock, 8 o'clock.
Okay.
Just say again, I might have missed it, Mr. Agrizzi, who was in the boardroom at that stage to which you're referring?
In the boardroom were representatives. I actually can't. There were representatives of each of the companies that were part of the bid submission. So it was Pezulu, Gordian, Livewire, it was Bosasa, people
Mavundla.
Sorry?
Mavundla as well?
Mavundla Ironclad, and Jacobitz's company as well was there.
And was this...
I'm sorry, Mr. Pretorius. At that stage, what was Better Fence's role, or had it fallen by the wayside?
No, Better Fence was there as well, Mr.
Oh,
Michael
Better Fence was there, okay.
Yes,
no.
but he was interacting more with Mansell and Watson.
Okay, but they were going to be, that is Better Fence, they were also part of the companies they were one of the companies that were going to be part of the bid.
They were one of the companies part of the bid, but they would not submit a bid because they were only a manufacturer.
Yeah. Thank you.
So present, as I understand it, were companies that would form part of the Pezulu fencing bid.
That is correct.
But would also, some of whom would also bid separately.
Yes. It had to look authentic, Jay.
Which one was that?
Some of the other companies would bid separately, so they would put in a bid, but then they would be told to put in a separate bid in their own company's name at a different price, so that it would not look obvious that it's only Pezulu bidding.
Yes. Those that were going to be subcontractors, I would imagine that Pezulu would disclose them in their bid to say, in order to be able to execute this project properly and efficiently, we will use the following companies as subcontractors. So my question is, was your understanding that their role as subcontractors was going to be made known to correctional services and to whoever in terms of it being public?
Chair, I cannot recall that.
You can't recall that?
I can't recall it at all, sorry.
Okay, but is my understanding correct that normally if you bid for a tender you would normally disclose whoever you will use as a subcontractor, or is that only sometimes?
It's only in the times of bona fide tenders and bids. This was caucused. This was corrupt. They didn't have to follow any rules, really. It just needed to appear real.
Well, I thought that Pezulu, being the ones that would put in the bid, may have wanted to be able to answer certain questions. Maybe they might not have bothered about them being asked any questions in the circumstances. Like, do you have capacity to do A, B, C, D? If so, how do you show us you have got the capacity? So if they are going to subcontract, they then say, we ourselves don't have that capacity, but we are bringing on board a subcontractor which has that capacity. So if you give us the tender, we will be fine. I thought that the whole scheme might still have contemplated that subcontractors would be made public on that understanding. But you are not sure.
It wasn't normal.
Yeah. Okay, all right.
Okay.
Before we move on to the next phase of your evidence in regard to the fencing tender, let's just summarize. At the beginning of the process, you have told the chair that BASASA had no capacity to provide high security fencing.
That is correct.
Certainly on the scale that was contemplated at the time.
Correct.
Not just a lack of capacity, actually lack of experience as well in this kind of job.
You're 100% right, Chair, and I'll substantiate that by saying that they'd asked me to put up a test panel, and it was a flop. We couldn't even do 10 meters of it. It was an absolute flop. I had a maintenance guy by the name of Henny Viljoen, who's mentioned in the statement, try and put it up. It was a gemors of note.
Yes.
You then described to the chair an elaborate and detailed set of corporate arrangements in order to build capacity.
Yes.
And you've also told the chair that there were persons who attended at sites to measure and calculate what would be required in relation to fencing quantity and perhaps quality as well.
That is correct, Chair.
My question is simply, over what period of time did this take place?
As I indicated earlier, I mean, just look at the number of sites times by the days. At minimum, 2-3 months before a tender even was promulgated.
Right, and this was all before the tender was promulgated?
Far before.
All right. Then
correct.
Perhaps after the break, we'll explain the relevance of that to the chair. May we take the short adjournment?
Yes, thank you. We'll take the tea adjournment and we will resume at 11:30. We adjourn.